Many people think that a will is just some writing on a piece of paper that expresses your last wishes after you pass away. Unfortunately, it's not as simple as that. So some of you may be wondering, how do you make a will? What can or cannot be included in a will? And why is it important to make a will? Well, in this presentation, we will be answering all of these questions and more in order to help you understand wills further. A will is a legal document that coordinates the distribution of your assets after your passing in accordance with your wishes. A will is important to have as it allows you to communicate your wishes clearly and precisely. તમારી સંપત્તિ તમારી ઈચ્છા પ્રમાણે વહેંચણી કરવી એના જે કાયદેસરના કાગળિયાઓ હોય તેને will કહેવામાં આવે છે. A will makes it much easier for your family or friends to sort matters out when you pass away. તમારા કુટુંબીજનો માટે will બનાવવું જરૂરી છે જેથી કરીને પાછળથી કોઈ પ્રકારનું મન દુઃખ ન થાય અથવા મૂંઝવણ ન થાય. Having a will removes the stress on family or friends in dealing with your estate after your passing, and very importantly, it brings clarity. સત્સંગ દીક્ષા શ્લોક 189 અને 190માં સ્પષ્ટપણે લખેલું છે કે ધન, દ્રવ્ય તથા જમીન આદિના લેણદેણમાં હંમેશા લિખિત કરવું, સાક્ષીય સહિત કરવું ઇત્યાદિ નિયમો અવશ્યપણે પાળવા. સર્વ આશ્રિત જનોએ પોતાના સંબંધીઓ સાથે પણ વ્યવહાર પ્રસંગે લિખિત કરવું ઇત્યાદિ નિયમો પાળવા. Writing a will is especially important if you have children or other family members who depend on you financially, or if you want to leave something to people outside your immediate family. A will can help reduce the amount of inheritance tax that might be payable on the value of the property and money you leave behind. To pass away without a will is called being intestate. If you don't write a will, everything you own will be shared out in a standard way defined by law within the intestacy rules, which isn't always the way you might want it. આ પરિસ્થિતિમાં will વગર ઘણા બધા પ્રશ્ન વધી જતા હોય છે. It can leave many unanswered questions about your personal property, real estate and finances. કોરોના વાયરસના લીધે અમુક વ્યક્તિઓ અચાનક મૃત્યુ પામેલા છે અને એવી પરિસ્થિતિમાં will ન બનાવવી હોય તો એમની ઈચ્છા મુજબ સંપત્તિની વેચણી થતી નથી. Making a will has particularly become an important question in light of COVID-19 and the trepidation surrounding the pandemic. If there is no will and no known blood relatives who can claim your estate, then your estate goes to the government as unclaimed. તમારા કોઈ પણ વારસદાર ન હોય અને આપના મનમાં એવો વિચાર હોય કે તમારી સંપત્તિ કોઈ પણ સંસ્થામાં ઉપયોગ થાય તો આ પરિસ્થિતિમાં વિલના કાગળિયા વગર તમારી બધી મિલકત સરકાર જપ્ત કરી શકે છે. એટલે will બનાવવું અતિ આવશ્યક છે. And lastly, if you're a sole director or a partner or proprietor of a business and you pass away without appointing a co-director or an authorized person, your business may be at risk. For example, because payments cannot be authorized. So these are some of the risks and implications of not making a will. Now let's go through the process of creating a will. How do you actually make a will? Well, firstly, you need to make sure that you're able to make a legally valid will. For this, you must make it voluntarily and be at least 18 years of age. You must make it in writing and be of sound mind. એટલે કે આપની માનસિક સમતુલા legal કાગળિયા ઉપર સહી કરવાની યોગ્ય હોવી જોઈએ. You must have the mental capacity to make the will. Otherwise, it's invalid. And any will signed on your behalf should contain a clause saying that you understood its contents before it was signed. And you must sign it in the presence of two witnesses who are both at least 18 years of age. It's also useful to know that the government has changed the law so that witnessing can now be done remotely by way of video conferencing in light of the coronavirus pandemic. The witness, however, must not receive a benefit or gift in the will they are witnessing. એટલે કે વિલમાં જો કોઈ હિસ્સેદાર ન હોય એની જ સાક્ષીઓ માન્ય હોય છે. So how do you make a lasting power of attorney? Firstly, you must choose your attorney. and you can have more than one. Secondly, you need to fill in the relevant forms to appoint them. And lastly, you must register your lasting power of attorney with the Office of Public Guardian, which can take up to 10 weeks, and it usually costs £82 to register. Once you have checked if you are able to create a will, where do you start? Wills are legal documents, and small errors can potentially cause significant problems. It's preferable to have someone legally qualified to draft it for you. You may consider visiting the Law Society website or the Institute of Chartered Legal Executives. Free Wills Month in England and Wales is also something to consider, but it's limited to both geographical areas and participating lawyers. Every March and October it offers, as the name suggests, free wills, but to get one, you must be age 55 or over. You must enter your postcode during March or October on the Free Wills Month website, and the website will list solicitors close to you who are taking part. So here are the things you can include in your will. Nichena points ખાસ તપાસી લેવા જોઈએ. Get an idea of what your estate will be worth by drawing up a list of your assets and debts. Assets that typically make up an estate include your home, any other property you own, including overseas properties, in which case you will need to acquire specialist legal advice from an expert in the local jurisdiction. Savings in a bank or building society account, national savings such as premium bonds, insurance such as life assurance or an endowment policy, pension funds that include a lump sum payment on death, investments such as stocks and shares or investment trusts, motor vehicles, jewelry, antiques and other personal belongings, furniture and other household contents, and debts may include mortgage or a credit card balance, bank overdraft loans, equity release, tax on legacies, and much more. Many people choose to leave some of their estate to charity when they die. Aside from supporting a cause you believe in, there can be tax advantages to giving your money away. If you leave more than 10% of your estate to charity, then the inheritance tax rate on the remaining of the estate will fall from 40% to 36%. This is called leaving a charitable legacy. For further information regarding inheritance tax, please visit .gov.uk inheritance tax. ઘણા વેલ વિશર્સ અને દાતાઓ સરજુદાસ ફાઉન્ડેશનના ચેરિટેબલ વર્ક માટે અમુક ટકા વિલમાં લખાવતા હોય છે. Recognizing the charitable activities of BAPS Swaminarayan Sanstha, many donors and well-wishers choose to leave part of their estate to Sarjudas Foundation to fund the charitable activities of BAPS. These include nurturing children, caring for the elderly, promoting health for future generations to come. If you wish to include Sarjudas Foundation in your will, then you can provide the details of the charity to your legal professional.
There are some things you cannot include when making a will. These properties name a beneficiary which avoid probate, meaning what you write in your will cannot take priority over the named beneficiaries to these properties. So first of all, we have something called joint tenants. The key characteristics of a joint tenancy are that you will own the property equally with whoever you are buying it with. Each person owns the whole of the property, meaning every individual has a 100% stake in the property's value. Joint tenancy ની ખાસ વિશેષતા એ છે કે તમે જેની સાથે પ્રોપર્ટી ખરીદી હોય તેમાં તમારો સરખા ભાગનો હિસ્સો અને માલિકી હોય છે. This is a popular choice where a property is being purchased with your spouse. Married couples that own property would typically be joint tenants. ખાસ કરીને તમારા જીવન સાથી સાથે મિલકત ખરીદીમાં આ એક ખૂબ જ પ્રખ્યાત રીત છે. A point we need to be aware of with a joint tenancy is the right of survivorship. The right of survivorship means that in the event of one of the owners passing away, the property automatically passes to the surviving person and becomes entirely their property, regardless of what is written in your will. For that reason, the right of survivorship will be prioritized in this instance and not your will, unless you break the joint tenancy before you pass away. Breaking or severing a joint tenancy can be done through a written agreement at any time. Severing a joint tenancy then becomes a tenancy in common. એટલે કે એક વ્યક્તિના મૃત્યુ પછી બીજા ભાગીદારી વ્યક્તિ હયાત હોય તો એના નામે આખી પ્રોપર્ટી થઈ જાય છે. પરંતુ જોઈન્ટ ટેનન્સીમાંથી ટેનન્સી ઇન કોમનમાં લેખિત કરી માલિકીપણાનું સ્ટ્રક્ચર બનાવી શકો છો. ટેનન્સી ઇન કોમનમાં તમારો ભાગ પ્રોપર્ટી કેટલો છે એ ચોક્કસપણે જણાવે છે અને આપના મૃત્યુ પછી આપના વિલ પ્રમાણે હિસ્સાની વેચણી થાય છે. Additionally, there are other types of property which avoid probate, meaning These take priority over what is written in your will. These include life insurance proceeds that have a beneficiary. In this case, the proceeds automatically go to the named beneficiary within the policy, often a spouse, child, or even a business partner. Retirement plan proceeds including money from a pension. The forms for these plans contain a section for you to include your desired beneficiary. Stocks and bonds held in a beneficiary. This is yet another type of property that automatically goes to your named beneficiary. Proceeds from a payable on death bank account. The form for this account asks you to name a beneficiary.
In addition, there are certain types of conditions you cannot include in a will. કોઈ પણ willમાં શરતી બંધન ના હોવું જોઈએ. These include marriage, divorce. દાખલા તરીકે તમે આ વ્યક્તિ સાથે લગ્ન અથવા છૂટાછેરા કરશો તો તમારા માટે વિલમાં ભાગ રાખીશું. એવી શરતો વિલમાં ન હોવી જોઈએ. If you care for children under 18, your will should set out who will become their guardian if both parents die. If you do not, the family courts will be left to decide who should raise your children. It is worth speaking to the guardians in advance to confirm that they will be willing to take in your children. Within your will, you can also specify where the money will come from to look after your children. This is usually provided for with specifically set up trusts. If children inherit money or property, it is held in a trust until they are 18 years of age or until they get married, if earlier. You can set out instructions for how the trust is to be managed. If you do not specify, the trust will be dealt with in accordance to the trustee laws, which let the executors deal with the fund. Aside from your children, consider any other dependents you might have, such as elderly parents or disabled adults living in your home, and make financial arrangements for their care as well. The next area is one that a lot of people don't like to talk about, and that is the cost. So how much does it cost to make a will? Well, the cost of drafting a reasonably straightforward will isn't as expensive as you might think. You can buy a template document in a stationery shop for as little as £10. On average, a simple will can cost anything between £144 and £240. A complex will can cost between £150 and £300. A will may be more complex if you have been divorced or have children. A specialist will that involves trust or overseas properties, or where you want tax planning advice, can cost a minimum of £500 to £600. Once you've written a will, what do you do if you want to make changes to it? Well, you can't ordinarily amend your will after it's been signed and witnessed. The only way you can change a will is by making an official alteration called a codicil. You must sign a codicil and get it witnessed in the same way as witnessing a will. And there's no limit on how many codicils you can add. Ideally, you should review your will every 5 years and after any major change in your life. For example, getting separated or divorced, getting married or remarried, having children, moving to a new home, or if the executor to your will dies. If you need to make major changes to your will, then you should just consider making a new will, in which case the new will should stipulate that any old wills are now officially revoked, and then you should continue to destroy any old wills in your possession. So there you have it. We've gone through the basics of what a will is, how to create one, and the benefits of having a will. Even though this is a topic we don't like to discuss, it is definitely something worth considering. For further information on this topic, please visit the links below. We hope that this presentation has helped simplify your understanding of wills. Thank you, and Jai Swaminarayan.